Hi, everyone. Let's talk about landlord tenant law and land use regulation. Right off the bat, I apologize for my voice. My whole household has had the flu and we're all recovering here, so I'm a little bit hoarse, but we'll see if we can get through this. So, for this lesson, we're going to define the landlord tenant relationship. We're going to describe landlord's duties to a tenant and the tenant's duties to a landlord. We'll explain how a landlord may transfer leased property. We'll describe how the government regulates the landlord-tenant relationship. We'll describe the anti-discrimination laws that apply to real estate. And finally, we'll describe the government's power of eminent domain. Landlord-tenant law can vary state to state. Where I can, I try to provide North Carolina's specific rules. But if you live somewhere else, you just have to understand and research the rules in your state. So let's get into the basics here. So the landlord-tenant relationship is created when the owner of a freehold estate, which we defined in the previous chapter, transfers the right to possess the real property exclusively and temporarily. That's pretty verbose and uses a bunch of big words. The basic idea is you're allowing somebody possession and control of your real property, usually for some temporary period of time. A lease is what's called a non-freehold estate. That just means that you don't have title or ownership of the property. If you're the tenant, you just have the right to possess it and use that property for certain purposes for some limited period of time. A leasehold is what you call the tenant's interest in the property. I have a leasehold estate in the property. Again, no ownership, but I have the rights to use it for a certain period of time for certain purposes. The landlord, otherwise known as the lessor, is the person who owns the land. The tenant or the lessee is the party to whom the leasehold is transferred. Most of us are familiar with this terminology, or at least familiar with landlord tenant. We may or may not be familiar with lessor lessee. We set that at the beginning because we'll use those words a lot as we go through the chapter. A lease is the transfer of the right to possession and use of real property for a set term in return for certain considerations. That consideration is usually money. Usually when I'm renting out a piece of property, they're paying me money in return, but other consideration could be paid, or no consideration at all sometimes. A rental agreement, it's also called a rental agreement. It could be called a lease agreement. It could be called a rental agreement. It is this contract that we have between a landlord and a tenant that sets out the terms for this lease. What's it going to cost? What period of time? When is rent due? What is included in that? And so forth. Most of us will either be a lessor or a lessee or both at some period in our lives. So it's important and very useful to have some background knowledge about how all this stuff works. So we'll describe a couple different types of tenancies, four major ones that we'll discuss. One is a tenancy for years, more commonly around here known as a fixed term tenancy. It's where we set out ahead of time, here's how long this lease will last, whether it's 6 months, 2 years, 10 years, however long. Some states, if you set a tenancy for more than 99 years, then it just becomes a freehold estate and you own that property. It goes state by state on that one. So a tenancy for years or a fixed term, the landlord and tenant agree on a specific duration. The lease does terminate automatically at the end of the stated term, and then you no longer have the right to be there. But in a lot of lease agreements, it can say that once the lease period expires, it might go into a month to month if you don't renew. You can modify a lot of the stuff in the lease agreement. So the lease agreement usually is going to be the controlling set of rules, and the state statutes would come in and take over if something was to violate state statute or something that would not be allowed to be modified. So important to understand what's in your lease agreement. That's tenancy for years. Periodic tenancy. Sometimes you let people live in a place that you own or you're renting from somebody else just on a week-to-week basis or month-to-month, and we don't set out a specific period or time at which the lease expires. We just know that we're going to renew week-to-week, month-to-month, and that's when I pay rent. So we can terminate a periodic tenancy at the end of any one of these periods, at the end of a week or at the end of a month or whatever, as long as I give proper notice. Now, proper notice It will vary by state. Here's where state rules can vary. So I'll give you some North Carolina specific ones. So in North Carolina, well, understanding right from the get-go that we can set this out in a lease agreement when notice has to be given, but here's the minimum I have to give according to state statute. So if it's year to year, then I have to give notice, what's called a notice to quit, 1 month or more before the end of the current year of the tenancy. So once that 1 year period is about to expire, I have to give them 1 month's notice prior to that, that I'm ending this tenancy and we're not going to renew it. Sorry, I had to take a break to cough. A tenancy from month to month. Okay, now I have to give a notice of 1 week, 7 days. Prior to that, the end of the month, I have to give notice of somebody when I'm going to terminate the lease. If it's a tenancy from week to week, I have to give notice of 2 days. So those are the state required notices, the state minimum there. And again, we can extend those terms in the lease agreement if we choose to do so. There are some special rules for people who live in what's called manufactured housing. We're usually talking about people who are living in mobile homes here, trailer parks and such. A little bit more protection for them just because these people tend to, not always are, but tend to be in a more financially vulnerable position. And I'm speaking as a person who grew up in trailer parks, so I'm not knocking anybody here. So some additional protection for people who live in manufactured housing here. Okay, jumping back into our types of tenancies. Another one is a tenancy at will. This is a kind where we don't necessarily set out a term. We just say, well, we'll just continue this lease until we decide that it's over. And we can, either party can terminate the lease at any time by giving proper notice. Again, proper notice varies state to state. In North Carolina, we'll follow the rules that we just covered earlier, and they'll determine the period as being just when are you paying rent. A tenancy at sufferance is created when a tenant retains possession of a property after the expiration of another tenancy or life estate. Keywords here, without the owner's consent. So I'm overstaying my lease period. This is not an actual true tenancy. A tenant at sufferance is technically considered to be a trespasser. That doesn't mean I can go grab them and physically throw them off my property. There are really no circumstances at which a landlord can go and physically grab a tenant and move them off of their property. We have to leave that to the government. That would be the sheriff's office who would do that physical removal of somebody. That's why I put this here. We still have to use legal methods to evict. That means physical force. It also means I can't just go and shut off people's utilities to try to freeze them out or burn them out or whatever. That would be called a constructive eviction. We'll talk more about that later. Okay, so those are the major types of tenancies. Now let's look at what duties tenants and landlords have to one another. So first off, what are the landlord's duties to a tenant? One is I have a duty to deliver possession. So I have to give the tenant actual possession of the property on the date the lease term begins. And I'm giving it to them, in most cases, for exclusive use, meaning the tenant's going to live in here, and that means that the landlord is not living there during that time. Now, there are cases where landlords and tenants share the same space, so yeah, there are exceptions, of course, but oftentimes what we're dealing with is exclusive use on the date the lease term begins. I also have a duty as a landlord not to interfere with the tenant's right to quiet enjoyment. We call this the implied covenant of quiet enjoyment. That means the landlord is not coming around and shutting off utilities. I'm not locking doors on people and changing the locks. I'm not just showing up at random for inspections without notice, that kind of thing. Interfering with this covenant of quiet enjoyment would be called a wrongful eviction or an unlawful eviction. A type of wrongful eviction is called a constructive eviction, which I just mentioned, which is, if you're a landlord and you have somebody overstaying their welcome, or if you suspect they're causing damage to your property, there's a legal process we have to go through going through the court system to get somebody evicted from the house. Oftentimes landlords will panic, or don't want to go to court, and they'll just go shut off utilities, or they'll just go change the locks when the tenant is out of the house. That's the kind of thing that can get you in trouble as a landlord. So we want to be careful to avoid legal trouble for the landlord. A landlord also has a duty to maintain the leased premises. So maintenance means the things that are required by whatever the lease terms are, whatever federal, state, local statutes are that govern any landlord-tenant relationship. So there are always going to be building or housing codes, examples of things. The flooring has to be adequate so you don't fall through it and get hurt. You have to have smoke detectors, carbon monoxide detectors. The house should be generally habitable. Somebody should be able to live in there, as you would expect one to live in a place. And if I'm failing that duty as a landlord, then the tenant can take me to court and sue me. I can also face potential other fees and maybe even criminal matters later on if I'm not really careful. So, mentioning that, on the same line of thinking, we're going to talk about the implied warranty of habitability. That's part of that duty to maintain the leased premises. That means that we have to provide leased premises that are fit, safe, and suitable for ordinary residential use. If I breach that, a tenant may, I'm going to caveat this here, there's some recourse that tenants have here. One is withholding rent amounting in an amount that reflects the loss of value. However, big caveat there, I don't want to just not pay rent. I don't want to do that. I'm going to have to go through the court system as a tenant to get permission to withhold rent. If something's wrong with the apartment that I'm living in and I just decide to withhold rent and I don't go through the court system, my landlord can just evict me for non-payment of rent. So be careful here. Same thing with the next one. If there's something that's broken and needs to be repaired in order for the place to be habitable, I could repair the defect and deduct expenses from my rent. Again, I need to talk to my landlord first and get their permission to do this, or get a court's permission, and not just do it on my own without asking them or against the landlord's wishes, just to avoid being evicted myself as a tenant. The tenant might be allowed to cancel the lease if the breach constitutes a constructive eviction, allowing them out of any penalties for breaking the lease or anything like that. And then finally, the tenant could sue for any damages that they might suffer as a result of the breach of the implied warranty of habitability. I gave you a link here for the state statute where a landlord has a duty to provide fit premises if you want to go and read the North Carolina state statute. So as a case example for the warranty of habitability, we have New Haverford Partnership versus Stroot. This happened in Delaware in 2001. Basically, a lady was living in an apartment and complained that there was mold growing in the bathroom. She complained enough to where she got moved to a different apartment, but that one seemed to be even worse. And at a certain point, the ceiling in the bathroom even collapsed because of how much moisture and mold had been up there. She complained of and suffered through many health problems as a result of all the mold and mildew and everything that was in the apartment. To the point where she was actually at trial awarded $1 million for Haverford's negligence. So then the question came, was Haverford actually liable? And if so, was the amount of the award of damages to Stroop actually appropriate? Okay, well, looking at the case from the facts, it seemed pretty evident that Haverford actually was negligent. They knew of the problems in the apartment bathroom and they declined to actually do anything to try to fix it. So she suffered health problems as a result. And then her health problems were such an extent that the court decided that the $1 million judgment was actually appropriate. So just a warning out there to landlords to make sure to take those tenant complaints or suggestions pretty seriously. Okay, so what duties does a tenant have to a landlord? Well, the number one is to pay rent. Okay, so as you get into real estate a little bit more, if you get into real estate a little bit more, you'll probably discover there's a difference between normal residential leases and then commercial leases. The basic idea is that you have to understand what's included in the lease payment. Generally, when you're just renting a residential area, they'll probably have you pay for your own utilities. You pay rent, and then you also pay for utilities, but then the landlord pays the property taxes. So that would be what we call a modified gross lease. A gross lease would be that you pay a rent payment and everything is included. The landlord pays for the property taxes, they pay for utilities and everything. That's very uncommon because you don't know how much electricity or water your tenants are going to use. So most use a modified gross lease where the tenant pays for rent and then they pay their own utilities. Commercial rental arrangements can take different forms. So if you're thinking about leasing a commercial space, you just have to understand what's included in the payment that you're making. In a net lease, the tenant is responsible for paying rent and property taxes. In a double net lease, the tenant's responsible for paying rent, property taxes, and utilities. And in a triple net or a net lease, the tenant is responsible for paying the rent, property taxes, utilities, and insurance. So if you're going to start a business and rent out a commercial space, you just have to understand what's included in the lease payments. You don't get stuck with some unexpected expenses later on. A tenant also has a duty not to use the leased premises for illegal or non-stipulated purposes. So if they find out that I'm selling drugs there or I'm running just an illegal business out of the property that I'm leasing, then I would be in breach of our lease contract. Also, the lease agreement probably has some stipulations about the ways in which the property can be used. And if I'm breaching that lease agreement in some way, then they could potentially have grounds to evict me. I also have a duty not to commit waste. Committing waste in this context just means causing substantial and permanent damage to the leased premises in such a way that it would decrease the value of the property. This does not include normal wear and tear. You know, certain things are sort of expected. You get a little scuff mark on the paint or something like that. But, you know, if I allow a giant water leak and it, you know, eats away at the bathroom floor, that would be committing waste. And then finally, I have a duty not to disturb other tenants. So harassing people or just playing really loud music late at night, stuff like that, that would disturb other tenants in a multifamily or a multi-unit building. Okay, sometimes questions arise when either I'm leasing property to somebody else or somebody's leasing property to me, and say I'm renting a house and my landlord sells the house while I'm still living in it. So what happens there? Do I have to move, or is my lease still good through the sale? And it can depend. So I have to pay attention to the lease agreement. The lease agreement might provide that if the property is sold, then I have a certain number of days to go ahead and leave. And then at that point, I would have to leave. If the lease doesn't say anything about it, the general rule would be that I'm still good through the lease period. And then I'm allowed to finish out that lease period before I could be asked to leave. But yeah, landlords can sell, they can gift property, they can devise, transfer it in any other way when it's subject to a lease. And then what happens just kind of depends on what the original lease agreement says. Okay, so leases can potentially be assigned or subleased, and so we'll talk about the difference between those two things. So an assignment of a lease is when a tenant transfers all their rights and duties under a lease to another person. And the vocabulary would be that the assignor is the tenant who transfers the rights under a lease, and the assignee is a party to whom a tenant transfers the rights under a lease. We're also going to caveat this and say that lease agreements can and probably should prohibit assignment without the consent of the lessor. So if I lease a piece of property that I own, let's say I have an investment house and I'm renting it out to somebody, and then they decide they're going to leave and let one of their buddies take over, I probably want to have some say in vetting that friend to make sure I'm okay with them living in the property that I own. So that's why it's a good idea in a lease agreement to restrict assignment without my consent as the landlord. Just an illustration. So we have the landlord who leases property to an original tenant. And then let's say they decide they don't want to live there anymore, but they're going to allow their friend to take over. So they would assign their rights over to the new tenant. That new tenant would finish out the lease period. Again, it's a good idea for me to reserve the right in the lease agreement for me to vet them first. And then once it's complete, then the landlord's relationship is now with the new tenant rather than the original tenant. Subleasing is a little different. It's very similar to assignment, a little bit different in a technical sense that I'm transferring only some of my rights as a tenant to another person. The vocabulary here would be the sublessor is the original tenant who is transferring some of his or her rights to a sublessee who would be the new tenant in the sublease arrangement. Now, this happens sometimes when maybe I'm leaving the country for a few months on business, and I would like for somebody else to temporarily take over my lease for a few months until I come back, and then I finish out my lease term. So I would sublet it for that temporary period of time. So that would be called a sublease rather than an assignment. I did this back in college. I rented out a guy's apartment for the summer while he was going home for the summer, and then when he came back, he took back over his lease, and we carried on with our lives. So the technical difference between assignment and subleasing is in an assignment, we're transferring all the rights. In a sublease, we're transferring some of those rights, a temporary period of time, or for a restricted amount of use, or whatever the restriction in the terms would be. There's your visual. It's pretty much the exact same, other than when I, the original tenant, am subleasing, we haven't really created an official relationship between the new tenant and the landlord. The new tenant would just be paying me, the original tenant. I'll also say that subleasing is another thing that can be restricted or prohibited in the lease agreement, and it probably should be, to get landlord approval if somebody else is going to be living in that property. Again, if I owned property, I would want to be able to have the chance to vet another person who's going to be living in my property, just because I want to do as much due diligence as I can to prevent damage to my property. Okay, so government regulation of real property. One such type of government regulation that we don't really encounter in North Carolina very much at all is rent control. So some cities, especially very densely populated cities like New York, Chicago, will sometimes have rent caps. And so that just says that the rent for this apartment is X number of dollars, and it can only be raised by X percent every year. And then that really keeps housing costs down for those particular units. It's pretty controversial because landlords feel like they're leaving a lot of money on the table because they can't lease the property out for as much as what the market value would be. And then other advocates would say that we really need a lot of affordable housing, and so maybe rent control is a good thing. I won't tell you what to think there. That's just sort of the basics of the controversy. Rent control is, in most cases, not legal in North Carolina. I gave you the state statute there. Now, there are certain government subsidized housing units that are allowed to be regulated with regard to how much rent can be charged. But outside of those narrow confines, then rent control is just not going to be allowed in North Carolina. We also have some government regulation in the form of anti-discrimination laws for real property. So we have the Civil Rights Act of 1866, which prohibited discrimination in the selling and renting of property based on race or color. Even though the law was on the books, enforcing it is a whole different matter, and we have a pretty complicated history of that. In the 60s, the 1960s, 100 years later, we have the Fair Housing Act of 1968, which makes it unlawful for a party to refuse to sell, rent, finance, or advertise housing to any person because of their, and then we have this list of protected classes. The protected classes under this one: race, color, national origin, sex, religion, disability, or family status. And this is administered by HUD, the U.S. Department of Housing and Urban Development. Prior to these laws, it was actually legal and common for landlords to be able to put a restriction in the deed saying that the property couldn't be sold to certain racial groups, insert whichever racial group you're trying to discriminate against at that time. Now, on certain old properties, some of those deed restrictions still actually exist in the public record, but they're just not enforceable anymore because I can't just refuse to sell a house to somebody or lease a house to somebody just because of their race. Or their religion, or all the other protected classes I just said. Next, we have Title III of the Americans with Disabilities Act, which prohibits discrimination on the basis of physical or mental disability in places of public accommodation operated by private entities. We also have, below all the federal regulation, states and municipalities can have their own fair housing laws, and those are allowed to be more restrictive than the federal regulations. They can't be less restrictive, or they could be, but the federal one would take over if the state one is less restrictive. So understanding what protections you have in the area where you live is a matter of looking at what are the federal regulations, what are the state regulations, and in my municipality, what regulations are there at either the city or the county level. I gave you a link to the North Carolina State Fair Housing Act, so you can read more if you're interested. We mentioned eminent domain in the last chapter, but this is a way, this is a very heavy-handed tool that the government has at their disposal, and it's supposed to be restricted to certain types of use. Eminent domain would be the process whereby a government could actually force a private citizen to sell their property to the government for some kind of public use. Now, this power comes from the Fifth Amendment of the Constitution. The very last part of it says that nor shall private property be taken for public use without just compensation. It's not that the government can't take your property. It's just that they have to justly compensate you, and it should be for public use. So those are the kind of the restrictions there. And we mentioned the big famous case, Kelo versus City of New London, in the last chapter, where that was the government taking property for another private business's use, which was a stretch, and it forced a lot of states to go in and modify their eminent domain laws, restricting the exercise of eminent domain, or condemnation it's sometimes called, to public use. So if we need to build highways, bridges, things like that, that would be for public use, eminent domain seems to be okay, but not just because another private developer wants to build another shopping mall there. Supposed to be anyway. The takings clause of the U.S. Constitution. So the takings clause and the just compensation clause are both parts of this Fifth Amendment of the U.S. Constitution. The takings clause is just that part that says, nor shall private property be taken for public use. And then the compensation clause says, well, without just compensation. So it's just those two little parts of that one little sentence that I gave you there at the top there. But when people are referring to the takings clause or the just compensation clause, that's what they're talking about. And finally, here at the end, I gave you a few additional resources. Oftentimes, people aren't really that informed about what their rights and their duties are as either a landlord or a tenant. And since so many of us are going to be landlords and or tenants at some point in our lives, I think it's pretty interesting to read up a little bit more just so both sides understand their relationship. So I'll give you some links there. Feel free to check those out. And with that, I'm going to let you go. I hope you have a wonderful day.